much awaited podcast, the podcast where we delve into the fascinating intersection of open source software and the legal landscape. I am Dr. Padmavati Roy, your host. We will together explore the key legal issues, challenges, and best practices that every developer, company, and contributor need to know about. Our goal is to provide you with the necessary legal insights and expertise to navigate the open source world with confidence and knowledge. In today's episode, we will be exploring the crucial topic of legal insights of open source software. This is a fundamental aspect of open source that can significantly impact your projects and business. We are privileged to have Greg Stein, a distinguished attorney with extensive experience in open source legal matters, whose insights and expertise on this topic are invaluable. Open source software has revolutionized the way we develop and share technology. But it is important to remember that with great power comes great responsibility and potential risks too. Being aware of these risks and challenges is the first step to being prepared in the open source landscape. Understanding the legal frameworks and obligations is essential to ensuring compliance, protecting intellectual property, and fostering a collaborative environment. So, whether you are a developer looking to contribute to open source projects, a company navigating the complexities of open source compliance, or simply curious about the legal side of open source, your role is crucial. This podcast is designed to empower you and provide the knowledge you need to navigate the legal aspects of open source. We appreciate you for tuning in and are excited to discuss today's topic with our expert guest. Thank you for your time and interest. Today, we are excited to have Greg Stein with us. Hey, Greg.
Hey,
And
Padma, thanks for having me.
yeah, I'm very happy to welcome you to this much awaited podcast on the open source and especially legal side. And for the listeners, Greg is a distinguished attorney with extensive experience in open source legal matters. So, Greg, welcome to the show. Please tell us about your background and how you got involved in open source legal matters.
Sure. So, my background's actually more in intellectual property law specifically, uh, but
Mhm.
joining DXC a couple of years ago, it's been now almost 5 years. Uh, Software, in particular, and intellectual property issues around software were clearly important for me to learn. So, through experts like you, Padma, and others, other colleagues within DXC, I learned more about open source software, free and open source software, what that means, and the intellectual property and other issues, legal issues relating to it. So I appreciate you calling me a distinguished and an expert, but I consider myself a student, and I love learning about this topic.
That is your humility, Greg. And great. And what drew you to specialize in intersection of law and open source software?
So focusing on intellectual property law, I what I was really interested in was the innovation aspect, the technology aspect, and incentivizing the creation of new things, new technologies.
Mm-hmm.
So, open source software to me, now that I've learned more about it, is a specific way of getting to that same end goal, right? So
Mm-hmm.
there are I'm gonna use my pulpit here, my soapbox to share a little bit of information with the listeners, but also throw in some opinion from time to time that are my own and not DXC's. But the four essential freedoms of free and open source software are important to understand here. Those are the bedrock principles, and those are freedom zero, which is the freedom to run the program as you wish for any purpose. Freedom number one is the freedom to study how the program works and change it so it does your computing as you wish, and to access the source code, which is a precondition of that. Freedom two, which is the freedom to redistribute copies so you can help others. Notice that the word copy is used in there. And then the third freedom, or the fourth freedom, depending on how you're counting, the freedom to distribute copies of your modified version to others. So those freedoms are the principles of the free and open source software movement, if you will. But copyright law specifically and other intellectual property laws are kind of the how. They're the motors, the gears that are making that work, right? So how do we get these four freedoms using these intellectual property laws? So that's how I kind of got focused in on this, was learning about the free and open source software movement and how intellectual property law has been used as a tool to further that for the same goals, but in a different way that intellectual property laws are used to incentivize the creation of new technologies and new copyrightable works under various jurisdictions' law.
Excellent, Greg. Yeah, you rightly mentioned about the four freedoms because these freedoms ensure that users have the autonomy to use, examine, modify, and share the software, fostering a collaborative and transparent development environment, and which is essential in today's fast-paced technology world.
Yeah, and
Right.
I was guilty of this too at the beginning. I thought free and open source software, or open source software, just meant that it was free as in beer, is what they say, and
Yeah.
that's just not the right concept. It's about providing the freedom to do certain things, and copyright law, which why that matters here is that when you create software, you write source code, that is protected automatically by copyright law.
Yeah.
So the copyright is going to be owned by whoever the author is, or in some cases, the employer of that author, depending on the jurisdiction and how it was developed. But that means that copyright owner has to give permission to others to have those freedoms. They're not going to have those freedoms vis-a-vis the source code without getting express permission from the copyright owner. So that's why we have all these different licenses that some look very different than others, but the goals are, as long as they're all aimed at ensuring those four freedoms, they're all aiming towards the same goals.
Yeah, so when you mentioned about various licenses and all, I have a question here. Can you explain the fundamental differences between the most common open source licenses that we keep hearing, such as the GPL, MIT, and Apache?
Yes, so there are many licenses out there, some of which are very unique and honestly unworkable. Anyone can draft the license if they want. It's literally just a written statement of what rights you are providing to the recipient of the software and under what conditions they're getting those rights. So I've seen some that are, one or two sentences. I've seen some that are, tens of pages. Usually don't go longer than that. But the ones that are most common are the ones that are well written and consider all the legal issues and risks. They generally, and I'm going to pause here just to say that I'm going to use the terms copyleft and permissive just for simplicity's sake, but I realize that some may have problems with those terms as they may be defined in the general lexicon, but basically carving out two generic categories, one being the permissive style of license, which means that you're not putting many conditions on the recipient. They're just receiving the rights, and that gives them the four freedoms. Whereas the copyleft style, I think there are various forms even of copyleft, but again, for simplicity's sake, let's say copyleft puts some restrictions on the end user in order to, in some cases, ensure that those 4 freedoms continue even after the recipient of the software. After that initial distribution, that it continues downstream. There are other styles of copyleft that are a little bit more business friendly. Maybe they're meant to kind of create a middle ground between a more traditional proprietary style license and an open source license. But if we're going to agree that the 4 freedoms are what free and open source software is all about, then copyleft software is just another means of getting there, but it provides some additional downstream conditions to ensure that you can't close up that code once it's been modified or distributed further after the initial distribution.
Okay. So yeah, that's really interesting to know. And what should developers consider when choosing an open source license for their project? For example, they choose MIT or Apache. What other things that they should, as a developer, I should consider?
You should probably start with what your goal is with the distribution at hand, right? So, and I'm using the term distribution in its legal sense, but just think of when I want someone to be able to take a copy, whether I'm sending it to them via some kind of remote transfer, or they're downloading it themselves, where it's posted publicly for people to download, or even giving them some kind of digital medium that they can copy it from. Those are all acts of distribution, right? So you're handing over a copy of the source code. So that's the trigger here. Understanding what it is that you want that recipient to do and not to do with that source code is where you should start. And then you also need to consider what happens once that copy is modified. You hand it to someone who then makes changes to it or incorporates it into a larger program. Consider where you want to go. It's not talked about already, the 4 freedoms, a few times, but that's not the only purpose for which some of these licenses can be used. So consider whether you want the 4 freedoms to be the kind of underlying goal, or that you have some other goal first, and then consider which license is going to be the best way forward on that front. So, permissive style license gives rights to the recipient in order to use the program for any purpose, but it also doesn't require, a lot of them do not require the recipient to then do anything specific with the source code. For example, to keep it open, to keep modified versions of it open. So those are the things you want to consider. What do I want the recipient to do with the source code? What do I not want them to do? And what would I be okay with happening downstream of that? If the recipient's handing copies to an end user or making modifications that they're going to distribute to end users, etc.
Yeah, so developers should consider all these things, what the end user or the recipient wants to do with this source code after they modify, where they are going to, what is the end outcome of that source code, and so on and so forth. So that is wonderful, Greg. Now let us understand the legal implications of using, let's say there is a commercial product and developers start using various different open source licenses. So what would be the legal implications in such kind of scenario? Can you shed some light on this aspect?
When you're using someone else's open sourced or open source licensed software, then you want to make sure that you're complying with the terms of that license. It's not the case that just because it's open source licensed, you're free to do whatever you want. That's not true, and you need to read the license to know what it is you have permission to do, what it is you do not have permission to do, which may not even be explicitly mentioned in there. And then there sometimes are obligations. So one very common one is attribution. So you as the recipient of a distributed copy need to ensure that any copies that you further distribute or any copies that are modified versions include sometimes it's a cut and paste statement that says, this software was originally developed by XYZ. Sometimes it's just including the copyright notice of the original software. It's really whatever's in the contract, the license that you're supposed to put in there. But the idea there is making sure that the people who have contributed to that source code over time are given some credit. And we can all, I think, sympathize with that, but that can also become burdensome when you have a lot of people contributing to one project. I don't think it's ever prohibitively an issue, but it certainly can be frustrating, from the developer side to think, oh well, now I gotta go find that giant list of contributors and copy and paste it over, or make sure the license files in the package and things like that. But that's the give and take. In order to, it's not free as in beer. It's free as in you have the freedom to do this, but as you said at the beginning of this podcast, you still have responsibilities as a recipient, and that's what keeps the open source community going.
Absolutely. Yeah. So it becomes operationally very difficult, as you rightly mentioned, for a developer to include the number of attributions in a particular code.
Yep. It compliance is definitely not easy, and that's why I think a lot of companies, especially, gravitate to a smaller set of licenses, of open source licenses, because those licenses have kind of tried and true requirements, especially in regards to what kind of things you need to make sure go on your modified versions, or what things don't. And they don't want to be subject to ambiguous restrictions or ambiguous requirements on what they need to do. So people know generally what to expect with things like the MIT or the BSD or the Apache v2 or even the GPL. Those are licenses that are used quite often, so people are familiar with the requirements under those licenses.
Yeah, so that's what you say. Many maybe organizations, sometimes they may choose to use the small set of license like MIT, Apache, or GPL because they know all these requirements.
Right, and then you have other licenses, and I don't know if you're gonna bleep censor anything after we do this discussion in post editing, but I guess I'll self censor here. I know I've seen a license out there that's called the do whatever the bleep you want license, and it's all it is I think it's like one run-on sentence that says, you can do whatever the bleep you want with this software, and whereas I understand where that's coming from. You're it's obviously tongue in cheek, but it's also I don't care what you do with it, do whatever you want. That doesn't give a lot of comfort to the people receiving the software. That they have been given specific rights and specific permissions, like, for example, the right to copy the software. Nothing in that license explicitly addresses the right to copy. You can broadly construe that statement. You do whatever the heck you want with it, but people want assurance so that they have the freedom to do these four things specifically. So if you, and that's why I generally think those kinds of licenses that are clearly not written in a legal sense are dangerous, because they invite ambiguity. And one of the points of having these contracts done by lawyers is to make sure that we make language as clear as possible and unambiguous as possible, so that as a recipient I can be sure of what permission I have. I don't have to worry that I'm going to get sued later on, or someone's going to be complaining about my not having fulfilled the requirements under the license under which I took the software.
Yeah. So in this scenario, like you might have seen many instances where you might have came across an organization faced some legal challenges due to improper use of open source software. Can you describe any scenario which comes to your mind?
Yeah, and I'll describe it generally, right? I can't discuss specifics of
Yes.
things I've worked on, either at DXC or before my work at DXC. But it happens. It is
Mm,
not. I will say it is not easy to enforce an open source software license, mainly because it's not easy to identify when someone is breaching your license, right? So
mm,
first you have to find someone using your source code, and then identify some way that they've used it that is not in accordance with the license under which they received it. And that's not necessarily the license that you licensed it under. It depends on which license you licensed it under and whether that would permit uh, other licenses to come into play, if it's involved and if it's included in a compilation of sorts. But if you find someone like that, which is low probability you're going to be able to find that happen, and know that they're in fact not complying with some aspect. But if you
mm-hmm,
do find them,
mm-hmm,
then you have to physically find them, because you're going to have to send them some kind of notice, um,
mm,
or bring them to court in order to enforce your contractual rights under your open source license agreement.
mm-hmm.
And then it's a matter of um, kind of discussing with that potential infringer what exactly they did and whether or not they have kind of a good faith basis for having done whatever you think the violation was. So
Mm-hmm.
things like, I forgot to put the attribution piece in
Yeah.
there.
Mm,
That's important to the copyright owner. I mean, it should be if they're putting it in there.
yeah.
Um, is someone going to sue someone over that? I doubt it, but they might get a
Mm,
notice saying, "Hey, I noticed that the attribution wasn't in there." Of course, they'd have to have a copy of the version that was distributed in order to know that the attribution wasn't included. But assuming
mm,
that all happens, then that can happen. So in those cases, I guess the point I'm making is, in those cases, kind of the outcome of the enforcement action, this being just a discussion at that point, is relatively minor, right? It's not like there's a big damages claim or anything. On the
yeah.
other hand, there are situations that, I'm not going to try to characterize them, but I'll just explain how they work. There are some business models where a company will dual license a
Mm,
software product, both under the source code they'll license one version under an open source license.
mm-hmm,
Usually in this business model, it's a copyleft style of license,
mm,
and it is free. You don't have to
mm-hmm,
pay for it. However, they also license another version, same software, but
mm-hmm,
they license it under a permissive model, or at least a model that doesn't have the copyleft requirements under it. The copyleft requirements I'm referring to are those that require that downstream copies also
mm-hmm,
be kept open source and distributed under the same license agreement. So those kinds of requirements can be lifted if you pay for it. And
mm-hmm.
that's the business model where I've seen sometimes uh, companies that are consuming those software products can get in trouble because they didn't keep
Yeah.
track. And it's not always easy to keep track, especially when version to version, uh, the license, kind of the licensing scheme changes. So sometimes it will be, version 7, they licensed under a permissive model, and then version 8, they decided they were going to do the dual licensing model. Or
Yeah.
version 7, they did the dual licensing model, and then version 8, they changed to a fully proprietary model, and they accepted an update to a new version without actually reading the license. I think
So,
that's where a lot of people get in real hot water, not just the, hey, you didn't put the attribution notice in there.
so why do you think organizations are the license they will select like this hybrid model, permissive and also the copyleft kind of licenses? Why do they have this dual licensing models?
Well, it's a way to try to get benefits from both styles of
Mm-hmm.
software development, right? So you have the proprietary side where everything's kept behind a firewall and your customers don't get to see into how the software works. They just get to use the software. That's a
Mm-hmm.
proprietary model. The other model is the FOSS model, where it's everything's open for everyone to contribute to, and the more people who contribute to it, the better.
Mm.
So they're trying to get the benefits of both by doing the dual licensing model. At the same time, uh, we don't have to name names here, but there are companies out there that expect that there will be non-compliance, and then they
Mm.
benefit monetarily from that non-compliance, and they have an active enforcement uh, campaign in order to go out and make sure that, and it's their right. It's
Mm.
their legal right to go and do that under copyright law and under the contracts that they distribute those uh, those source code products. So it's not wrong of them to do, but it does seem, I will say, in my opinion, it does seem a little off that you're just betting on non-compliance in order to turn a profit.
Mm. So when we discussed about the legal implication and a scenario which I was asking you to explain from your own experience, uh, but these legal challenges, what is the root cause for having these legal challenges faced
Not
by
reading the
an organ?
license. It's
Mm,
always not
okay,
reading the license. I mean, that
okay.
it sounds like I'm oversimplifying maybe, but that's the issue.
Mm,
Um, you click and download. We're all guilty of it. I'm included in that. You get the uh, the little pop-up window that says,
mm,
by clicking this or signing this, you agree to these terms and conditions. Sometimes it's a hyperlink to a separate page, and then you go to that page and you're scrolling through, a web page that's just full of legal text and jargon, and that's annoying, and you just click it.
yeah,
But
exactly.
in the case of open source,
Mm,
none of this works without the restrictions and requirements. Now, not every restriction or requirement is necessary here to ensure the four freedoms,
mm,
but the way this whole system works is you it's kind of like you take it as you find it. You're taking the source code because it's available to you. All you have to do is click it or download it.
mm,
You get a copy of it, but you get it under the terms at which it's made available, which are these open source license terms. And it's on you as the recipient
mm.
to make sure that you're complying with those, or else you may be called um, you may be called to pay up in some cases where you haven't made those. And normally the damages, very few cases I've seen where there's an enforcement action based on an open source license, but the ones that I've seen at least usually center around the requirement to the copyleft requirement in a copyleft style license to make sure that copies, the unmodified and modified versions of the source code that are further distributed are also made available under the same license.
Uh-huh.
That's usually the one that I see people get tagged on, because then the damages are easier to calculate because it's based on the lost licensing opportunity.
So whenever we want to use the open source, the best practice is to read the license to ensure that we are actually understanding what kind of license, and then also when we use or redistribute, we are understanding its license completely.
Yep, and I'm not going to pretend like licenses are easy to read, although I read
Mm,
them a lot. Um, they're still hard for me to understand sometimes.
mm,
First step is reading it. Second step is, if you don't understand it, you got to ask
mm.
questions of whoever the licensor is, if you can. In some cases, it may be impossible from a practical standpoint to contact the licensor, or you get legal counsel to help you. And
Yeah.
that's our job as legal counsel, is to
So
read the license and then advise based on what we think the risks are.
Yeah, I think that is a very good way of approaching these things and preventing. First is reading the license. Second thing, if possible, contact the license owner. And then third, if not, then approach your organization's legal um,
The other
legal team.
the other piece, Padma, that I think kind of comes before the what you do when you know you have open source software that you're dealing with is to keep track of
Mm,
the open source software you're dealing with. So
yeah.
one common way to do that is to make sure that you're including a software bill of materials in any packages that you distribute,
Mm-hmm.
so that that recipient knows exactly what's in there. You've laid
Yes.
out for them um, the different ways to do it. I'm not an expert in that, but the general idea is the software bill of materials tells them this is the code that is included in here that I've obtained from other sources. And
Mm,
usually it'll have information like where it was obtained from, the license under which it was licensed,
mm.
uh, and those kind of things.
Goes to my next question. What are some best practices do you think for organizations to ensure compliance with open source licenses?
Yeah, I think it's good to have a compliance process. You don't necessarily have to have a board or a review mechanism that's that
Mm-hmm.
formal. It just depends
Mm,
on the size of your company and the resources you have to do it. But there should be some step or process, step by step
mm,
process, I guess, through which you're one identifying open source software that uh, you are you are licensing, right? You're using the source code. You have a copy of the source code which is subject to the license. You're identifying it. You're keeping a record of it. You're reading the license terms and making sure you're complying with them. And then when that software uh, when that source code gets compiled into or added into another program or modified in any way, that is also kept. You're keeping
mm.
records of that, and then letting any downstream users know um, that that information is included. Otherwise, finding the open source software when it hasn't been recorded can be difficult. I know there are plenty of automated tools out there that that purport to be able to identify all of the open source code
Mm-hmm.
within a particular package, but um, that wouldn't be necessary so long as everyone were keeping good records of what they're including in their open source software packages or their proprietary packages if it
Mm-hmm.
includes open source. You're not disclosing anything uh, proprietary if you tell someone what open source packages you're including.
Okay. So are there, you were mentioning about some tools. Can you share some of these names of the tools that an organization can use for managing their open source or managing the compliance process?
Yeah, they're different tools for different parts of the process. So there are code scanning tools out there.
Mm-hmm.
Um, I'm not familiar with any particular ones other than some of the ones we use at DXC. I don't want to specifically mention those just because I don't know much about them other than that we use them. But there are some platforms like Black Duck
Mm,
that have a lot of these tools and kind of an overall management system so that you can
mm-hmm.
keep records and make sure that the right people are approving uses and you're keeping track of where third party open source software is coming into your organization, where it's going out. So that can be homegrown, and it
Okay.
doesn't need to be complicated, but it has to scale with the size of your business, and it has to from a best practices standpoint, it needs to work within your development workflow, right? It
Mm-hmm.
can't, it shouldn't be a burden to your developers. It it's going to be a burden to some degree, but it should be minimized, right? So it should fit within the workflow, so that they know every time this is the stage at which I check that I'm complying with open source license, or this is a stage at which I'm going to scan and make sure that I have documented all of the open source components that are in here, and that I've generated a software bill of materials that can be shared with downstream users. So having that documented, having a clear process, and making sure that all fits within the development workflow, I think is the best way to do it. But other than that, very flexible as to how your organization works, as long as you're making sure that legal counsel is involved at some point. Right? I wouldn't recommend keeping legal counsel out of the loop entirely on that.
Yeah, absolutely. You're right. So, how can developers ensure they are complying with the license terms of their open source software?
I'd go back to read the license and get legal advice from your in-house counsel.
Yeah. And how should companies conduct an open source software audit? Are there tools we have already gone through? Um, but how do you think from your experience, how should companies conduct an open source software audit?
Yeah, I'm not an expert in that. I'll freely admit. Again, tools like Black Duck
Mm.
and other software composition analysis tools, which are those scanning tools, can help. But there are other ways to do it. Prevention, I think, here is probably far cheaper than
Yeah.
licensing or purchasing a scanning tool. And the prevention here is just keeping records of things as they come in and making sure that you know what's in your code, you're keeping track of the licenses, and you're documenting that for your customers or your end users, right? So if they have questions, they don't have to come to you later. You've already shared with them all the documentation they need in order to contact the owner of that code directly.
Yeah. When we uh, discussed on the audit related things, uh, I remember this open source review board. Do you think all the organizations need to have a review board for the open source software? If yes, then what should be the responsibilities of such kind of a review board?
No, I don't think every organization needs one. There are two functions I think that an open source review board can provide. Probably more, but the two important ones to me are one, being the approval process for
Mhm.
open source software, and it's not just reviewing the licenses; it's also reviewing whether the source code
Mm.
meets whatever standards your organization has. Right? Because uh, sometimes open source software is kind of cast in a different light, and it doesn't go through our procurement processes that we would normally
Mm.
have. Open source code, in my view, should undergo the same level of scrutiny from a quality perspective as any other software. Now, it may be your responsibility as the recipient rather than the owner to
Mm.
make sure that you shore up any uh, issues you see, bugs, or and you may decide even to contribute those back to the project, but that's going to be on you. And then the other side from the approval process, the other thing the open source review board can do is provide more of like a policy and process guidance, and
Mhm.
provide recommendations to leadership on what they should be doing. The law develops. Sometimes issues pop up that need to be addressed from kind of an expert level, and an open source review board can help with that, so long as your open source review board has, in my view at least, a broad scope of experts, right? So you need people who understand open source software development,
Mm.
people who understand your product, people who understand your legal requirements, uh, regulatory issues. All those different perspectives need to be brought to play from that policy angle, and those are not necessarily the same people you want doing the approvals. The
Yeah.
approvals can really just be legal and then technical side. But
Yes.
an open source review board can do both of those things. It doesn't have to, and you don't necessarily need. I think the approvals process is is needed, but it doesn't necessarily need to go to an open source review board that sits outside the development process. That approval process can be built into the software development process. It just needs to be done so thoughtfully. And then, the issue there is going to be training and education. That means you're distributing that responsibility to your developers to be, to some degree, experts in open source software compliance. And that's fine, but that is hard and takes a different level of investment.
Oh, yeah. So you wonderfully put everything together, Greg, on the OSRB. So basically, it's a kind of a cross-functional team consisting of legal experts and also technical experts and also engineering or product development. And also there should be one open source compliance officer and IT infrastructure and so on and so forth. So they are functioning as one team, and they will be uh, involved in these kind of open source reviews and also maybe not maybe the approval process, right? Approval process, you mentioned that legal team will be taking care of the approval process, but
And the technical team, yeah.
yeah,
So
yeah.
those functions don't have to sit within an open source review board. And I would say the kind of policy piece, the process piece, that can be owned by one person if you have the right person, or if your organization is small enough that you only have one person.
Yeah.
So it's the approvals part that I think is the requirement, because you have to make sure that if all of this is to work, you got to make sure that you are complying with the open source licenses in order to benefit from them, right? Without all of these requirements, the benefits of open source licensed software can't be achieved, because there's not going to be the community of people in order to develop and learn from your source code.
Yeah. So, in this, linking this with any policy requirements, should companies have regarding their employees who are contributing to the open source project from a large organization perspective, or any organization for that matter?
I don't think there's a right answer to that.
Mm-hmm.
From the contribution standpoint. Companies should make clear in my mind, companies should make clear to their employees if and when it is appropriate to contribute to an open source project. I won't express an opinion on which way to go on that. It's up to each company. In some cases it may not be appropriate, in some cases it may be, but you got to make sure your employees know whether they can contribute. And then if they can contribute, then there are a few more questions to answer, like what is your position on contributory license agreements, which are, so those are referred to as CLAs, and those are agreements under which you as a contributor to an open source project are licensing your rights to the project so that the project can then distribute the software, including your edition. And some companies just have a default rule that they refuse to sign CLAs because they don't want to be subject to any liabilities on that side. Some companies have a process for reviewing those. They get legal involved. Some companies will just sign them. But I think there's also another side, which is just the responsibility piece. If you're contributing to a project, then you need to make sure to be a responsible member of that community and that project. That you're sharing everything you got. You're including all of the right documentation. If you have any kind of administrative responsibilities vis-a-vis that project, that you're fulfilling those, or if you're not fulfilling those, you're handing those responsibilities off to someone who's going to actively manage that project.
So, in connection to that, I want to ask another question, a continuation of the previous one. When you mentioned CLAs, I want to ask how do contributor license agreements work and why they are important?
Well, I think I already answered most of that. Why they're important is kind of the same reason why recipients of
Mm-hmm.
open source software should expect a written license agreement when they receive source code. It gives the project assurances that they're not going to be liable for using the source code in the way that is intended by both the project administrators and by the contributor. Right. So if a project, an open source project, were not to do CLAs, which and some don't, then they're kind of going on faith that contributors won't come back and say, I didn't give you permission to use my contribution in this certain way. And that's the
Yes.
fear. And it's a, I think there is tension there sometimes. From the legal perspective, it's always better to have it in writing and made clear in writing and a record of it. I think from the practical side, having it in writing can maybe be seen as antagonistic. I don't see it that way as a lawyer, but I understand the concern that you don't want contributors to feel like the CLA itself is kind of a burden because they need to review it and then kind of sign a legal agreement, and that's just a big obstacle for them contributing to the project. I get that, but again, if we're relying on the four principles as kind of the underlying purpose here, then it is that those legal agreements, those licenses that have all this legal jargon in it that actually create that freedom. So without those agreements, you do not have those freedoms, because by default, under copyright law at least, only the copyright owner has the right to make copies, make derivative works, distribute copies, publicly perform, publicly display the source code.
Yeah. So, can you explain the concept of a patent troll and its impact on open source projects?
I'm going to pass on that one, Padma.
Okay.
I think that's an entirely different discussion, and I don't want to get lost on that one. If you want to do another podcast on patent trolls, another point, let me know.
Yeah, sure. So, yeah, let me move ahead then. So, now, how do you see the legal landscape of open source evolving in the next 5 to 10 years, especially with the AI, artificial intelligence, and machine learning picking up?
I don't foresee open source issues becoming less important. The idea is that source code can be freely distributed. So I think the logical endpoint on that is that these things will just be everywhere, right? If you make distribution easy, then they will pass freely from person to person until they're everywhere. So I think the result is, if we haven't reached it already, and obviously this is a process that, depending on which package we're talking about, we should all assume that there's open source in any package that we're dealing with, especially ones that are being handed to us. And I'm not a developer, but from developers that I know, at least, my understanding is that it's very difficult to create new software that is wholly original, right? That doesn't include some open source in it, for example, because that's the whole point, right? Is there's no reason to recreate the wheel.
Yeah.
With a lot of these things, when you can just go pick it up off of GitHub, subject to an open source license and subject to your compliance with those requirements. So I think probably at least 10 years ago, it was kind of a, if there's open source, components in our software or open source third-party open source software that we're using, then we should follow these steps. I think now and in the future, it's just assume that it's there,
Yeah.
and then work through how we identify and then comply with the requirements. The AI stuff is interesting. I don't want to get too bogged down on that because we could again do another podcast on it. But
Yeah.
I think the ability, especially of generative AI, to create stuff that is from a user standpoint just seems to be new and coming from nowhere. There's a lot of concern out there about how open source software specifically is being used with things like generative AI that creates new software code. And I've seen a number of companies that sell those kinds of products or provide services like that starting to do a better job of making sure that there are controls in place. They're not perfect controls, but for example, GitHub Copilot has a filter, a public code filter that you can toggle in order to, I guess theoretically, filter out any code that exists on GitHub before the results are displayed to you of what's been generated. Now, how accurate that is, I don't know. I don't know if it can be 100% accurate, but it does leave some concern that you as the recipient, we talked about this generally, that kind of you as the recipient want to have some assurances that you have all the rights you need in order to use the software. Well, when something's generated by not a human and it's just kind of laid in front of you, then you don't have any assurances.
Yes. Yeah.
And that's the tension. So how that plays out, I'm not entirely sure. I suspect that however it turns out, it's not going to slow down the progress of these tools being used. There's just going to need to be some kind of workaround to make sure that we're doing the best we can with regards to complying with our open source obligations.
Yeah. Thanks, Greg, for that. And how can developers stay informed about the developments happening or the legal developments in the open source community?
Yeah, so there are a number of organizations out there. Free Software Foundation is one. There's GNU. There's OSI, the Open Source Initiative. So these organizations all, I think, purport to promote open source software in general, but how they do that and particularly what kind of their goals are differ slightly. So, subscribe to what you want. But those organizations, I think, are generally seen, especially OSI and the Free Software Foundation, are seen as kind of the seminal ones. And I think it's also important here to reiterate that none of this works without there being community in the broader sense. So, people are encouraged, should be encouraged to reach out to each other. If you get an open source license, if you get a source code that's or if you get software that's given to you under an open source license, or you see, even if you get something proprietary that's given to you and without the source code, and you see that there's an open source component that's distributed under a copyleft license, then you should be reaching out to the owner and saying, well, why am I not being given access to the source? Or asking questions about the source or how it works, interrogating things, contributing to open source projects in repositories, online repositories like GitHub. I think being active in these communities is what makes these things work. I mean, I've mentioned the legal side and the licenses as being a tool to make sure these freedoms are assured. But at the end of the day, none of that works without the people, the open source community involved, right? Because the whole point is for there to be this open discussion uh, open use and free use of these software programs in order for those software programs to be developed more efficiently and with more people providing different perspectives on what should be added, right? So it's all in kind of
Mhm.
that idea that the more people that contribute, the better, and
Mm.
you just need to be a responsible community member to make sure that that all works.
Yeah. So, can you recommend any resources, books, or websites for developers and our listeners, and also even companies looking to learn more about the legal issues, about open source legal issues?
I would start with OSI and the Free
Mm-hmm.
Software Foundation websites. They
Okay.
have,
Mm-hmm.
I mean, I haven't been through all of it. They have tons of information and
Mm.
resources for you. There's also like the Linux Foundation. They have plenty of materials. You don't have to be a member necessarily to get access to some of those resources. So learn about especially some of these larger open source projects. I think is really helpful to understand how they work, and then making sure that you really understand. To me, I think the foundational principles of open source, no matter which version of it you subscribe to, because there are different versions. Uh, just understanding kind of the history of it's important here. Otherwise,
Yeah.
you lose track of why we're doing it. It's not
Yes.
the purpose of it is not to make it difficult
Mm.
by having kind of a click-through license that you don't have to read. That's not why we have open source. Open source is meant to create a community in which you get better software at the end of the day
Yeah.
because more people have touched it.
Yeah. Yeah. That is the essence. And how can our listeners contact you or follow your work?
Welcome to look me up on LinkedIn,
Mm-hmm.
and I'm pretty quick to respond there. So just find me on there, Greg Stein,
Mm.
currently at DXC, but I should be easy to find there. Or if you're ever in New Orleans, look me up.
Thanks, Greg, for that. And do you want to make any closing comments?
Just thank you for inviting me. Glad to be a part of the conversation here. And you've had a number of very impressive speakers, and um, honored to be included in the group. So thank you.
Thanks a lot, Greg. And that wraps up the open source legal insight episode. We have delved into intricate legal landscape of open source software, exploring various topics, starting from the free software, uh, the four freedoms of the software and OSRB, and also some kinds of websites that Greg had given us for our listeners to go through, check OSI, Free Software Foundation, Linux Foundation, so on and so forth. And thanks to Greg. Thanks a million for you for sharing your valuable expertise and perspectives. Your insights have truly enriched our understanding of the legal challenges and opportunities in the open source world.
Thank
And
you.
thank you for tuning in. If you enjoyed today's episode, please consider subscribing to our podcast, leaving a review, and you know where to reach out to Greg. You just visit LinkedIn and he can be contacted. Search for him. I will add the link to his LinkedIn profile uh, in the description box as well. And your support help us continue to bring you more insightful conversations with industry experts. If you have any questions, comments, or topics you would like us to cover in future episodes, please contact us on social media or via our website. We'd love to hear from you and are always looking to improve our content based on your feedback. Stay tuned for our next episode. Thank you once again, Greg.